Good morning everybody and welcome back to the channel. Today I'm so happy and really happy to do this video because we want to share with you some really huge and wonderful news. Everybody are talking about the so-called minor cases, and today we are here a couple of cases that we really recently won with a minor case. So today, as you may understand, will be a really huge video. It's a really important video for the entire process of the Italian Citizenship by Descent. So keep watching the video until the end because I will describe you what happened in these cases, so how the minor cases was won in these cases. It's Marco Bersani as always from the Bersani Law Office from Italy, and do not lose any more time. Let's start. I will briefly start to explain a little bit what is the minor case and why these decisions are so important. We call a minor case when there is Italian ancestor who had a child and the Italian ancestor naturalized when the child was still a minor. With a recent interpretation was made last year, actually in July 2023, published on July 2023 from the sentence decision of the Court of Cassazione, and was also made on this January 2024. So there are now two decisions from the same civil court of the Supreme Court of Cassazione that ruled about this type of cases. This section of Cassazione said yes, when you have an Italian ancestor who naturalized and the child also born abroad and so considered citizen of that country by birth, then the naturalization of the parent also affects the minor. So basically the line is closed and you cannot apply for Italian citizenship by descent. And when the first decision was made by the Court of Cassazione, the Supreme Court of Cassazione in 2023, with also the following in January 2024, of course, this created a lot of discussion into the, not just of course in the legal world, but also a big discussion during the community. So all the community made by all the applicants for citizenship by descent, of course, because these type of cases were always approved with no doubt. So this new interpretation created a sort of chaos. Since that moment, some people started to renounce to apply because there's a minor case. But our recommendation was to continue to fight the case because the decision made by the Court of Cassazione is not necessarily mandatory, does not obligate the Italian court, the local courts to follow that interpretation. And indeed, there are the courts in Italy, the local court, a few local courts for the moment, that are still approving the minor case. So this is a really huge news. Now I want to start by explaining what happened, so I will briefly explain you the cases. There are two cases. There is one case that was notified us, the decision was made in March 2024 on 28th, so it's really recent, and we are posting this video in April, so we are talking a case that was approved like 2 weeks ago, and another case that was made in February 2024. So both those cases are not just recent, but our cases are coming after the two decisions of the Court of Cassazione regarding the minor case. So it's clear that the tribunal, at least these tribunals, are approving the minor case, which is amazing. It's an amazing, wonderful news. So let's go in detail what happened with these cases and how these cases were won by our firm. The first case is coming from the Tribunale, the Court of Palermo. Palermo is in Sicily. We filed this case at the beginning of 2023. We have a typical family of 4 applicants, so father and children, that wants to apply for Italian citizenship by descent. In this type of case, we have 2 Italian ancestors. We have a male ancestor, so the great-grandfather and the great-grandmother. They had the child, female, so the grandmother of the applicant, the main applicant. This was made in the US. After the grandmother was born in the US in 1923, after that, the great-grandfather naturalized as American citizen in 1935. So the grandmother was minor. The grandmother was 12 years old. There's a clear minor case. So what happened with this case? Pay attention that this case is not a 1948 case. Also, if we have a grandmother and so on. The case is also interesting because we have a so-called lack of appointment case. So the client, we decided with the clients to file the application with the court because the clients were not able to file an application through the local Italian consulate because there were no appointments available to the local Italian consulate. So when you are facing this type of situation, so you are unable to book an appointment, so you are unable to file an application, basically, you can file your petition through the Italian court. If you never heard about this path, the so-called lack of appointment of path, you can watch our videos that we posted on our channel. You can see here a link to the videos too. And so the judge made a really interesting explanation, and actually the judge approved and confirmed all our statements that we did when we filed the application. We did an explanation saying that, of course, we have a case that must be approved because the old citizenship law, the law 555 of 1912, the Article 7 says that when you have an Italian citizen who went abroad, who emigrated abroad, and then had a child, the child was born there, and the child was considered citizen of that country because born in that country, like it happens in the US, the child kept his Italian citizenship got by 𝘿𝙤𝙨 sanguinis, and only when the child will be adult, the child will have the right to decide if continue keeping their Italian citizenship rights or renouncing to Italian citizenship. So the judge says, yes, in this case we apply the Article 7 because we have a child born in the United States, so the child was American by US territory, by American territory, and so, says the judge, it has no relevance what happened next. It has no relevance if the parent after naturalized, so change citizenship. According to the Article 7 of the law 555 1912, the child maintains his right because the child didn't choose to renounce to his right of the Italian citizenship. So the judge may make a really interesting explanation of how it works and the fact that the Article 7 must be applied, which is different from what the Cassazione said about the minor case, because the Cassazione says no, the Article 7 is not applicable because we need to apply the Article 12, which is another article. So this is very important. And the judge also agreed on what we said into the case. In what we said is the following. We recalled another decision from the Cassazione that was made in 2022. A decision which is also more important in some ways than the minor case interpretation made in 2022. Why? Because the Cassazione in 2022 made a decision in a so-called sezione unita, so section unified. Says that in the moment you got your Italian citizenship by blood or by any means, nobody can touch your Italian citizenship until it's you to formally renounce to your citizenship, to your rights. Nobody can touch your rights until it's you to want to renounce to your rights. We also recall also the declaration, the Universal Declaration of the Human Rights that was made by International Convention that was made, which is also of course important because we are talking international law, in terms of the protection of the human rights, and citizenship is considered a human right. So nobody can touch your right of citizenship until it's you to formally renounce to your rights of Italian citizenship. So we have a minor case that was approved. This is, as I said, approved on March 28th of 2024, so a few weeks ago. There is a minor case that is approved, which is really wonderful. Let's see then the second case I want to explain, want to talk about, which is a case that was processed by the Tribunale, the Court of Firenze, Florence. Here we have a case that was actually decided on February 2024. In this type of case, we have a similar situation. Basically, we have also almost the same situation because we also have one Italian ancestor, so the Italian ancestor who immigrated to the United States. In the United States, the ancestor had the child born there, and after a few years, so when the child was a minor, the Italian ancestor naturalized as an American citizen. So here we we have the same situation, and also, the same situation because we also have a lack of appointment case. Here the judge made a short statement, but basically they recall the same principle. Basically they recall what is the decision that was made, and all the principles that were stated by the decision made by the Supreme Court of Cassazione section unified in 2022. So all the principles that we also use in the same court petition in Palermo, so the first one that we explained, and so the fact that you can renew to your Italian citizenship only if you voluntarily renew, or if you voluntarily decide to take another citizenship. So, for example, if you want to become an American citizen, then you file a petition, you take a oath of allegiance, and so in that moment you sign renunciation, because the oath of allegiance says I renounce to my previous citizenship because I want to give entire loyalty to the United States government. There is no renunciation, so the naturalization of the Italian ancestor didn't affect the minor. The child remained an American because born in America, in the United States, but also has the right of Italian citizenship because he got the right of Italian citizenship through blood, by blood, when he was born. That's very, very important to note. We are totally optimistic that new minor cases will be approved. And that's really, really important, as every time we want to highlight the fact that right now we are in a situation, we are in a sort of gray zone. So right now, if you are facing a minor case, you have not to be scared. You have to fight your cases, and those cases are the demonstration that if you can fight your case, you also have the chance to win your case, because you have not to be scared of what happened in 2023, because what happened in 2023 is not necessarily something that will be mandatory for all the judges. Maybe there will be judges that will agree with the president. We don't know that for the moment, but there are also other judges, like in this case, they don't agree with the interpretation, so they are continue to approving the minor case. So keep fighting your case. Of course, if you have other questions, something you want to ask, of course, you can also leave some comments below to the YouTube channel, YouTube video, share your experience, share your thought. Please remember that we cannot do consultation through YouTube, so if you post questions, if you post something, we cannot reply to your question on, legally speaking, but you need to book a consultation. You need to book a consultation, so you can contact us through the website, through the contact form. You can send us requests for checking your case, to ask our advice, and you can book a consultation call, which is of course the best way to proceed, because we can make a Zoom call with you, we can analyze your case, we can reply of course to all questions, and we are able to suggest you the best strategy, the best way to proceed for your case, because each case is different, so we must be analyzed of course on case by case basis. Now we have plenty of pending cases, so as soon as we will have new decision, we will for sure make another video talking about the minor cases again, to share with you all the decision, what happened, so all the news, all the updates. So keep following the channel. This is really, really important, because every time we have a news, every time there is something to talk about, we will make a video, and we will try to make the video as best as possible to be clear as best as possible, because of course it's not always easy to explain the legal wording to all the people. So, but we will try to do our best. Thank you so much for your time. Keep following us also on the YouTube channel and all the social medias, and see you on the next videos.